Hello, everyone. We welcome you to the first session on Foundations of Canadian Law. My name is Amar Ahmed. I'm a barrister and solicitor. So, your instructor is going to be Ms. Hannah Mall. She is also a barrister and solicitor in Ontario. So, the name of the website is NCA Online Teacher. So, I'm going to show you what resources you have already got. So, you would type in the Google and then this NCA Online Teacher website will show up. So the first tab is free recordings. You can let anyone know that if they want to access the free recordings. So these are the free recordings on different subjects. For Foundations of Canadian Law, today's first session recording will also be posted here. We are also happy to introduce this new initiative. If you look at the second tab, it says Canadian lawyers. Just within the last few days, we introduced this idea of connecting Canadian lawyers with those who need their services. So, starting from the very beginning, you can see that all of them are Canadian lawyers, starting with Mr. Mickey Amiri, who is the Minister of Justice, and then all of them are these senior lawyers. In the first rows, there are many senior lawyers, but starting from the this row, so many of these lawyers have been attending our classes. So starting from the third row, so these are our members who have been attending the classes, but some of them are just the senior lawyers. So you can see we wish all of you your name to be here once you are done. These are Canada-wide, and we just introduced this initiative, I think, within a few days. Now we have reached the maximum cap. We will wait. Now I think there are 51 lawyers on this. Now moving forward is and this is a trust. This shows a trust in our services. The third tab is called live tutoring sessions. So here we have group tutoring, personal tutoring, immigration classes, mock test, and renewal of my course or book a consultation. So all of you have joined for group tutoring. So you click on group tutoring and then you see options to purchase different subjects. So you just add to the cart the way you do the online shopping. One, and this is our Ontario Bar Services. We have single course enrollment, we have live classes, we have only recordings, and then we have crash courses. So there are 7 or 8. Most of you live in Ontario. So once you complete your NCA process, here is a ready-made resource for you. The next is the recordings. If someone just wants to purchase the recordings, then these are the recordings. You click here and then you can purchase recordings at a very low price. The next is called question and answers for different subjects. We have prepared different question and answers. They are extra resource. So they are not part of the group tutoring because this is a foundations of Canadian law. So here is a sample question for foundations of Canadian law. Once you have purchased, then on the right side, you can see sign in. You will sign in and then you see this, which is inside of the website. These are called recordings. So please look at the green button. It says recordings. These are the latest recordings. However, NCA has recently changed the syllabus. So we will be using the latest syllabus in during our classes, but it is advisable to listen to the recordings. For example, you can see lesson 1, topic 4, April 2025. Lesson 2, topic 4, April 2025. So we start from topic number 4, and then Hannah will give you the reasons for that. So all these are the latest recordings. So in the last April session, we conducted almost 13, 14 sessions, and every session is around 2 hours. So you could expect maybe 26 to 30 hours of live tutoring classes. So 30 hours of live tutoring classes. Then we click on the option of instructor's notes. So when we click on instructor's notes, so these are the notes, and we are happy to announce that we have updated the notes as per the latest syllabus. So these are the brief notes, case laws, and summaries for July 2025 exam. So you click view full screen, and then you will be able to download them. You will be able to print them. So these are the notes available. Um, these are the new notes available for the topic 2. So there is a topic of Aboriginal topic 2. So topic 2, there is another different instructor, but there are total of 10 topics. So 9 topics will be taught by Hannah Moll, who is a barrister and solicitor in Ontario, and one topic which is Aboriginal topic, a very detailed topic that will be taught by another instructor. These are some question and answers. So this is also part of the group tutoring. You don't have to pay extra for that. This is included in your group tutoring fee. And the group tutoring fee is mentioned under the uh, group tutoring tab. That's it. So this is how we work together. We are the largest team in the private sector for providing educational services in the field of NCA and Alberta and Ontario Bar, sorry, not Alberta, Ontario Bar. And then we also provide services if you want to learn immigration law, criminal law, family law, intellectual property law. So this is a brief introduction of our services. This is the largest team in the private sector in Canada. 2 or 3 more lawyers will be joining soon. This is how we work together. If you will have any questions, how to join, or website related question, administrative questions, fee related question, then I am the person to contact. As some of you know, I have recently joined a law firm in Calgary, and then, but you are welcome. I am very quick to respond. All other instructors who teach different subjects, their job is to answer your questions relating to that subject which they will be teaching. So most of you are members of the regular foundation group. So one group is free, that is free foundation, free criminal, free constitutional. So we have, I think, 13 free WhatsApp group. But once you pay the fee, then we add you in the regular group, like regular foundation, regular criminal, regular constitutional. Most of you are familiar, but this is for those who are attending the class. So you have any questions relating to schedule, relating to your subject, you will be posting in the regular foundations group. If your access expires or when the recording will be uploaded, that is the question you can be posting in the group and I will answer that. Having said that, my role is over. Now the actual teaching session starts. Yes, Anna, please.
Good morning, everyone. I hope you're all doing very well. Some of you already know me. My name is Henna. I'm a barrister and solicitor in the province of Ontario. And this is our first free and introductory session on foundations of Canadian law that is based out of the new syllabus that was updated by the NCA for July 2025. So whatever we will be discussing in this session does not constitute legal advice. And, it's only meant for educational purposes. The second thing is that you are requested not to record this session, take screenshots, etc., because it constitutes breach of privacy, not just my privacy, but the privacy of every single candidate attending today's session. With that said, I will start sharing my screen, and we're going to start with the very first, 1 second. So this is your syllabus, right? So my first, why this is important, because I understand some of you might not sign up with us, and that's totally fine. But though even those candidates should be able to derive maximum value from this session. So the best way to do that is to first identify what changes have been introduced in your syllabus for July 2025. I had already posted this on an earlier occasion in Free Foundations of Canadian Law group, but as I understand, plenty of you have joined after that. So you may or may not have this PDF, which carries my comments and carries highlights. Now, when you look at this, the first thing that has changed is your book, Bryden, Kennedy, etc. So please understand, the book is called Public Law Cases, Commentary and Analysis. The book has not changed. What has changed is the edition. Up until July 2025, we were studying from 4th edition. This is the 5th edition, right? So what we are looking at is it's like a software update. We are not looking at the book has not changed. It has been updated in terms of edition. So that's number one. Number two, let's look at topic by topic. Now let's focus on the content. So in the first unit, there is no change. So that's good news, right? Second one, the changes are going to be taken up by Titilola. She is going to be your instructor for topic 2. So she is going to talk about the change, but just in case, like I said, for those of you who might not be with us, please note, this is the new article that has been added, Ghislaine Otis. Under topic 2, subtopic D. Now, from under topic 3, what they have changed is that they have added this topic, Brace Samuel L., concept of common law. So this is a new article that has been added. They had another article under this topic, which was by Ben McFarlane on lessons learned from the law of equity over 150 years. It was essentially a book chapter that has been removed, and I'm very glad it has been removed because it was not an easy article to navigate. Instead, we have this particular article that has been added. Excuse me. Then in topic 4, under topic 4, the topic that we will start off with, they have added another article by Lon Sossin. So under topic 4, there was just one article earlier by Jeremy Weber. Now they have added another article by Lon Sossin. I would request everyone to please place themselves on mute because it interferes with the class. Okay, thank you. 1 minute. I'll start sharing again. Apologies for that. So this Lon Sossin's article has been added. It's a commentary on, not really a commentary on, it's pivots around a case, Ron Corelli versus Duplessis. It happens to be one of my favorite cases to read because I'm fond of reading case laws. This is a fantastic case law to read, so I'm glad they have an entire article on that. Then there is no change in case laws, no change as far as Unit 5 is concerned. Unit 6, no change. Unit 7, this is Unit 6 only, so no change. Under Unit 7, again, there has been no change whatsoever. Unit 8, no change. Unit 9, they have added a case law that is called TELUS Communications versus Federation of Canadian Municipalities. So this case law has been added. This is a 2025 case law by Supreme Court of Canada. Right? And then under your final topic, we have this article by Paul Daly that has been added. It's a blog entry. So earlier on, we had a different article, but now that article has been removed and they have added Paul Daly's article on standards of review of regulations. These two articles continue to remain. They were a part of your previous syllabus as well. So as you can see that there has been a substantial change in terms of articles and case laws. So this would give you an idea how the focus of the exam and your syllabus has now undergone a change. And we are going to be studying that through each and every topic. Okay? Any questions about changes that have been introduced? Anything that you would like to ask at this point in time? I'm happy to answer. Any questions, anybody? Shireen, Yajur, Mike.
What are the changes in the book itself?
So in the book itself, what they have added is they have updated some case laws, and I would be talking about them as we proceed.
Okay, thank you.
Any other questions, anybody? Jasleen, Adeline, Vidya, Uluchi, Ricky, Fina, anybody, any questions? Okay, so I'm going to assume you don't have a question at this point in time, and we are going to start with topic 4. Now, some of you might wonder why I start with topic 4. And the answer to that lies in your syllabus. Now, when you look at your syllabus, you find that topic 4, the title of topic 4 is exactly the title of the syllabus. What is your syllabus called? Foundations of Canadian Law, right? And topic 4 is called the Fundamental Principles of Canadian Legal System. So when we talk about foundations of Canadian law, we have to start with the fundamentals of the Canadian legal system. Once we are able to fully grasp topic 4, we can easily proceed and finish other areas. And I'd show you how. Now, topic 4 says parliamentary sovereignty. And it talks about separation of powers. And then it talks about judicial independence, correct? Now let's look at what is topic 5. Topic 5 is Parliament. It's on Parliament. And so is topic 6. So if you understand this particular parliamentary sovereignty as a concept, and what is Parliament, and what does it do, and what are the functions of the Parliament, suddenly chapter 5 becomes very easy because you've already dealt with the basics. Then let's look at, and not just chapter 5, chapter 6 as well. Then what is 7? Executive and its functions. This is essentially how a different arm of the government works. When you look at topic 8, it's courts and judiciary. So if we understand topic 4, suddenly our journey to other topics becomes very simple. So I always start with the fundamental principles of Canadian legal system because it allows me to work on your basics and then build up from there. So that's the reason we always start with topic 4. right? I'll keep coming back to your syllabus to indicate how we are proceeding. The next thing is that I'm not going to limit myself to the case laws that are given over here. I have often been accused of teaching hundreds of cases, and I don't mind the accusation because it's true. And the reason is that this subject is essentially case law heavy. We are also going to do some articles that are not given in this syllabus. Now, you might want to know, why are we doing that? The reason we are doing that is because those articles are necessary to understand the context of these articles. So we are going to also talk about some of those articles. We are also going to talk about articles that are given in the book, because your syllabus, even though is GPS, it says any other prescribed reading. It has this open-ended introduction when it comes to foundations of Canadian law, which is quite unlike the other areas or the other 4 compulsory subjects. This one requires a deeper and an intuitive understanding of what we are doing, right? So again, any questions about how are we going to proceed and things that we are going to cover? Any questions on that? I'm happy to answer all questions because, like I said, I do not want anybody to go back with a doubt. Swastiga, hi, we haven't met in a long time. How I hope you're doing well. Muskan, Razia, Kuram, Vijay, Aaron, Nishtha, Ricky. Any questions, anybody? Okay. Let's just then start. Now, when we look at topic 4, we are essentially talking about the fundamental principles of Canadian legal system. Now, before we even talk about Canadian legal system, we have to understand the difference between what is public law and what is private law. Public law is the branch of law that essentially talks about an individual's relationship with the state and the civil society. So your criminal law is public law. Your constitutional law is public law. How you interact with the state and the society falls within the confines of public law. Private law, on the other hand, governs the relationship between 2 individuals or 2 corporations or 2 private entities. So tort law is private law. Contract law is private law. Essentially, when you govern the relationship between 2 entities, it falls under private law. But when your relationship is governed with the state, the civil society at large, the law that governs that is public law, right? And this distinction is important because our focus at all times, it's going to be on public law and not private law. We are not really going to talk about contracts. We are going to talk about parliamentary sovereignty. We're going to talk about democracy. So what is your relationship with the Canadian legal system or the Canadian political system? Now, let's start with the Constitution of Canada. And it is here that I want to show you how Constitution of Canada exactly looks like. So just give me a minute. Why it's important, you'll just know. Just 1 minute. Now, when you look at Constitution of Canada is not a statute. It's not a book, okay? It is essentially Constitution Act 1867 plus Constitution Act 1982 or Canada Act 1982 plus all the schedules that are attached to the Constitution Act 1892. So essentially, your constitution or the Canadian Constitution is not one constitution. It is two statutes put together along with all the schedules that are attached to it. And any amendments, any orders that are made to the schedules automatically become a part of the Canadian Constitution. And I want you to remember that, because this is what we're going to talk about in our very first case today, how schedules to the Constitution Act 1892 in fact constitute, or schedules to Constitution Act 1867 are a part of the Canadian Constitution, and therefore any amendments that are made to those schedules automatically becomes a part of the Constitution. So let's look at these schedules. What schedules are we talking about here? So you have the British North America Act, which is 1867. You have the act that establishes the province of Manitoba. You have the act that talks about Northwestern Territory. So you have the Alberta Act. You have, the Saskatchewan Act. You have the Canadian Deputy Speaker Appointment Act. You have the Rules of Secession. You have the Act of Westminster, Statute of Westminster. So pretty much all these acts that you can see are a part of the Constitution. So when we talk about what is the Constitution of Canada, you need to know that it's not just your Section 91 and Section 92. It's way, way more than that. It's far deeper than that, right? So when we look at Constitution Act 1982, there is a section under that, which is Section 52 sub 1. This section is also known as the Supremacy Clause. What does this mean? This essentially means that the Constitution of Canada is the supreme law of land. That means the supremacy of the Constitution is established under the Constitution itself. So let's say if there is a question on, because you also get multiple choice questions under, in foundations of Canadian law sometimes. And there are about 20 multiple choice questions and true and false questions in our sample question and answer package, because multiple choice questions come pretty often. If there is a question that says, where is it given that Constitution is the supreme law of land? The answer to that is in the Constitution itself, under Section 52 sub 1, because it establishes the supremacy of the Constitution. So it's not declared anywhere else. It contains within itself the seat of supremacy. Okay? Then Section 52 sub 2 says that Constitution of Canada includes the Canada Act 1982, which we just saw, acts and orders referred to in the schedule, which is your British North America Act, your Alberta Act, your Appointment of Speakers Act, your Statute of Westminster, your Act of Settlement, your Rules of Secession. They all form a part of the Constitution, and any amendment that is made to the act or the order referred to in para A and B. So when we talk about Constitution, it's a fairly expansive definition that we need to remember. And we also need to remember that any act or any law that conflicts with the Constitution, that is inconsistent with the Constitution, then to the extent it is inconsistent, it's of no force and effect. Now, what does this essentially mean? What does it mean? So let's say I have a statute with 100 sections. In that statute, there are 4 sections out of those 100 sections that attack the constitutions, that attack your charter rights for some reason. Let's go with the easier one. Let's say it attacks those 4 sections, they attack your charter rights. What is going to happen to this legislation? Will it be pulled down completely? Will you pull down this legislation completely? Then what's going to happen?
No.
Why? Is it not conflicting with the Constitution?
Only those 4 sections.
Only those 4 sections. Are you very sure? Because, I think the The law should be struck down, right? It's against the Constitution.
Not the whole law. It's only those 4 sections to that extent. So,
You're very
which are
sure?
there.
You're very sure about that?
But if Hannah, if the 4 sections form the life of the statute, the very essence of the statute, then it can lead to the striking down of the entire law as well.
That essence of the statute is something, all of that is a part of constitutional law. So if I start talking about how you actually conduct an analysis on legislation, then I'm actually entering into dangerous territory here. Not that I have a problem, but yes, Yajur is absolutely right. If there are 4 sections that conflict with the Constitution, then those 4 sections would be seen as of no force and effect, and the rest 96 sections are going to survive. Any questions on that? So it's not that you strike down the entire law. We only blue pencil the sections that are inconsistent with the Constitution. So let's say if the section says you are prohibited from traveling freely throughout the length and breadth of the country. Of course I can. It impacts Section 2D of my charter. Freedom of movement and association is a given. So that particular section is going to be taken out, scooped out of the legislation, and the legislation will survive. Any questions, anybody? Jigna, Champika, Mimi, Nicole, Daniel, Henny, Abby, Jasleen, Wave, Vijay, Ricky. All right. Guys, make the most of this session, especially if you're not a regular student, because this is important from the perspective of understanding how we are going to how we are going to view the entire syllabus. Now, when we look at the principles, they're essentially 1, 2, 3, 4, 5, 6. 6 principles that we're going to focus on. Number 1, rule of law. Number 2, constitutional supremacy. Number 3, federalism. Number 4, parliamentary sovereignty. Number 5, judicial independence. Number 6, separation of powers. And now we are going to dissect each and every principle and dive deep into it. But before I progress, any idea about what is rule of law? Rima, your thoughts on rule of law? Rima Sood, your thoughts on rule of law?
No, Hina, nothing as of now. I'm just listening.
Okay. Anybody, their thoughts on rule of law? What is rule of law? What does the name suggest?
Everybody should follow the same rules.
Okay. So you basically saying all of us are governed by, a crisscross of the same laws and we should.
Mhm.
Okay. Anybody else? Your thoughts on what is rule of law?
Equality before law.
Equality before law. Okay. Yes. I heard some other person speak as well. Your thoughts on rule of law?
No one is above the law.
No one is above the law. I like that.
No one can
Nicole,
beyond the law.
no one is beyond the law. Excellent. Nicole, your thoughts on rule of law?
Everyone has pretty much covered it. And what I want to include, like anyone includes like government bodies. Everyone is treated equally under the law, basically. So yeah.
All right. So, as I understand, yes, equality, reliability, stability, yes. So you have covered pretty much everything, but I want to talk about rule of law in a different context. You see, none of these principles that you see are given in the Constitution except rule of law. So rule of law is in fact enshrined in it's written in the Constitution. What does this mean? Is that when we look at the law, we look at both substantive law and we look at procedural law. which essentially means that how law treats Muhammad is not different from how it will treat Avinash, and it will not be different from how it's going to treat Vijay, and definitely it's going to be the same for Jasleen and for Amar and for Makani. Law remains the same. We all operate under the same umbrella of laws. However, there is another aspect of rule of law that we are going to talk about when we study Roncalli versus Du Plessis. This aspect is how rule of law also means that there cannot be any arbitrary exercise of power. What this means is I am not going to abuse the process of law. If I am in a position of power and Shireen is my friend, I am not going to reduce the law to a plaything in my hands to favor Shireen as opposed to Ravneet. It puts an onus on me as the lawmaker and also as someone who is an elected representative of a particular province or the country, that I do not differentiate between two entities by abusing my power. So when we look at rule of law, we talk about how the law needs to be same. It needs to treat everyone equally and also prohibits what I call arbitrary exercise of power. You cannot abuse the process of law. So it essentially means equality before law, equal treatment of law, and having a body of laws that is stable, predictable, and represents the will of the people, essentially. So when we talk about rule of law, we are not looking at one characteristic of law. We are looking at multiple characteristics in terms of how law should be. I think, there was an article 2-3 syllabus revisions earlier. I think this was in 2023. Let me see if I still have the article. It was one of the most fantastic articles on rule of law that I had read. I don't know why NCA removed it. It was one of the best articles on the rule of law. If you're interested, I can share the summary with you, because that article spoke about how rule of law is a bundle of 7 characteristics. It is one of the best articles that I have ever read on rule of law. And it is one of those articles that I say that even if NCA has removed it from your syllabus, you please read it because of the sheer value it will bring and the way it's going to improve the quality of your answer. I'm slightly digressing here. Yes, Rima, I'm thinking I'll share that here. Just give me a minute. But I'm glad you're showing interest in it. See, Foundations of Canadian Law as an exam requires you to demonstrate to your examiner that you understand the concept, right? And that you were able to not just understand the concept, you were able to also express yourself and have an opinion. No other NCA subject gives you the space to have an opinion of your own, but for this. And in Foundations of Canadian Law, if you do not have an opinion of your own, then it's problematic. One of the reasons candidates fail this exam is that they are not able to demonstrate to the examiner whether they have understood the topic and what's their opinion on the topic. So when you would see the sample answers, because those are some, we have free sample question and answers for our regular candidates. There are about 5 of them. You would see how in each one of them, I have added body and articles and case laws that are not given in your syllabus. But what it will do to your answer is that it will take your answer notches higher. The idea that this exam is about expression and understanding is absolutely on point. I think that's the reason we have the kind of results we have. I mean, it's upwards of 98, 99% every single time. Touch wood. And I would want to see that being repeated from this cohort as well. And one of the reasons we have is we are able to tap into, for the lack of a better word, NCA's emotion that surrounds this subject. So we actually stress a lot on resources that are not given in your syllabus so that you can add things that other candidates won't, right? So you want that article now, or can I give that later, Rima? Because if you want that now, you'll have to, I'll take about 2 minutes to search for it.
No,
Is it
you
okay?
can, yeah, you can share later.
Yes. So what I will do is, for our regular candidates, I'm going to share that article in our regular foundations group. Like I said, it is one of the best articles that I've read. Now, that article fully captures rule of law. So imagine if you were to mention those 7 characteristics in your answer, which only you would, because like I said, it's no longer a part of your syllabus. So others, if they're studying foundations for the second time, they won't even know that 2 years ago it was a part of your syllabus. So it's because that is not available right now. If you make a reference to that, imagine what it's going to do to your answer. So I'm going to share that in our regular group after this class, or perhaps by the end of the day, because I have back-to-back sessions today. So, like I said, rule of law is a bundle of characteristics, right? So it includes stability of law, predictability. It prevents arbitrary exercise of power. It says how power should not be exercised capriciously. It talks about equality of law. It talks about equal treatment of law. And it says essentially everyone is operating under the same umbrella. Okay. Any questions on what is rule of law before I progress to case laws? Any questions? Any thoughts? See, feel free to share your thoughts. And sometimes you might not want to, you might say, ask yourself or question yourself, oh, is that even valid? Feel free to ask. Because what it will do is it will clarify your doubt. I consider it a personal failure if any of you go back after the classes with a doubt. So let me know if that works for you.
Hannah, I have a question.
Yeah.
You mentioned before that rule of law is enshrined in the Constitution and written in the Constitution. Were you referring to Section 52? Is that where it is embodied, or is it mentioned
It's
somewhere
mentioned
else?
I'll tell you exactly where it's mentioned. I'll do a quick Constitution search because it tells you that how this 1 second. Constitution Act 1982. If you look at it, that's the opening sentence of Constitution Act 1982. Wait. Do you see this? Whereas Canada is founded upon the principle that recognize supremacy of God and rule of law. That's where it's mentioned. Opening sentence of your Constitution talks about rule of law.
Thank you.
You're very welcome. Okay, I will start sharing my screen again. This is one function of Zoom I've never been able to understand, that I have to stop sharing in order to go back to the file that I was sharing. It's painful. I hope Zoom does away with it. Now, the cases on rule of law. The first case law is called Manitoba Language Rights case. It's a reference case. For those of you who are not familiar with what is a reference case, I have given. So throughout these materials, there are footnotes given. Now you might want to know, what are these footnotes? These footnotes are essentially given to elaborate on certain terms and terminologies that might be new to you because you come from a different legal system. Reference question is essentially a question that is asked by the provincial cabinet to Ontario Court of Appeals and by federal government to Supreme Court of Canada. When, let's say, they're about to pass a law and they need some sort of guidance on whether this law can be passed, or whether they want to know whether a particular law is constitutional or not. So sometimes, because they are unsure of the impact a particular legislation may have, they go to either Supreme Court of Canada or Ontario Court of Appeal, depending upon which level of government we are talking, and they ask a question. This question appears as a reference question. So you would realize that throughout your syllabus, you will not have a versus, because there are no two parties here. There's no conflict. It's a reference question. So you have plenty of reference questions. You will have something called a reference re Supreme Act case, Supreme Court of Canada's Act, Supreme Court of Canada Act case. I refer to that a lot. You will also have another reference case which we discuss, which is Same-Sex Marriage Act. So again, lots of reference cases. Now, when we look at reference Manitoba language rights, it came in the year 1985. The question that they had asked in this case was whether the government of Manitoba, okay, let me start with some historical context. Now, in 1870, the government of Manitoba enacted something which is known as the Manitoba Act. All right. This Manitoba Act contained a section which was known as Section 23. As per Section 23 of Manitoba Act, the Manitoba was supposed to be a bilingual province. What this essentially means that all the laws of the province are going to be both written, printed, and published in English and French. So far, so good. Is this clear? What happened? They passed an act, the Manitoba Act. This act was attached to Constitution Act 1867. And this act contained Section 23, which said that the provincial government is going to print, publish, and write, print, publish all the laws in both English and French. Now, in the year 1890, a primarily English-speaking premier was elected in Manitoba. And he had his vote bank, which consisted of Anglophones. So in order to appease and make this vote bank happy, he came up with a law, as in the provincial parliament came up with the law, which was called the Manitoba's Official Language Act. As per that act, Manitoba was supposed to be a unilingual province, and the laws would be written only in English and published only in English. Now the question is, was the provincial government or was this act or was this law constitutional? So the federal government, in fact, went to the Supreme Court of Canada to understand whether Manitoba Official Language Act, which was passed in 1980, which passed in 1890, which declared Manitoba as a unilingual province, is it constitutional or not? What's your opinion? Is this act constitutional? Is the story clear? What happened? Any issues with the story?
The story is clear.
What?
It's clear.
Excellent. Eben, Rima, Rafi, Shireen, Yajur, is the story clear? Timelines and stories clear?
Yes, Hina, story is clear.
Little
Now-
confusion about timeline.
So Manitoba Act came in 1870. It became a part of the Constitution Act 1867. And then 1890, the Provincial Parliament of Manitoba passed another law known as Manitoba Official Language Act, per which Manitoba was created or was supposed to be a unilingual province. Now the timeline is clear. So in 1870, you have the Manitoba Act, and in 1890, you have the Manitoba Official Language Act. Manitoba Act 1870 was attached to the Constitution Act 1867. Now my question is, if the story is clear, what is wrong with what's happening?
The 1890 Manitoba Official Language Act is going against Constitution because
Yes.
1871 was attached with
Attached.
Constitution.
Yes, absolutely. And that's exactly what Supreme Court said. They said, you know, we don't care if you are the elected representative of the people. You do not play with the Constitution. You don't mess with the Constitution. You want to appease your vote bank, go ahead and do it. But you are not going to do at the expense of the Constitution because the law is the same. Manitoba Act is governs Manitoba the way Alberta Act governs Alberta and Saskatchewan Act governs Saskatchewan and New Brunswick Act governs New Brunswick, right? So if all the premiers decide to keep coming up with acts that are inconsistent with these acts which are appended to the Constitution, I mean, what is going to be left of the rule of law? What will happen to rule of law? Do you see the are you able to sort of dig your teeth into the concept?
Yes, Hina.
Thank you, Rima. Champika, Heni, Khurram, Disha, Rafi, Ivi, Felisa, sorry, Fasila, my bad. Monica, Kirti, Nicole, Tony, Ezine, Shireen, are you with me? Ravneet, everybody. So exactly. So let's go back and we are going to. So I have given a little bit of history here because there's a very interesting history. There was a rebellion in Manitoba in 1870s, so on and so forth. So the Supreme Court held that Section 23 of the Manitoba Act 1870 was mandatory. And the ratio of this case was constitutional supremacy is the heart of the legal system. I have actually quoted from the Supreme Court of Canada's case. It holds that our constitution is separate from and above other laws. Unlike statutes, the Supreme Court held that the interpretation of constitution should not be shaped thank you, Rima, should not be shaped by the use of a doctrine which is applied for the sake of expediency. I mean, just because it's easy, to publish laws in English, we are going to do it. You cannot do that. So when you see conclusion, usually this conclusion is something that I've taken from the case itself. But the idea is that you understand the certain background as to what is it that we are dealing with here. Because I actually have a grouse with the way case laws are presented. They'll just simply give you they just simply give you what happened in terms of what was held. I'm like, don't tell me what was held. Give me the story. Tell me the facts. Unless you tell me that, what was held will make no sense to me. Right? Now, let's study another case. Reference Race Secession of Quebec. Those of you who follow the news, we know a similar movement is taking place in Alberta right now. And, your premier, those of you who are from Alberta, Daniel Smith, is trying very hard to separate from the Federation. Unfortunately, it will be denied because it is unconstitutional. And the reason is that Alberta Act is attached to the Constitution. So a referendum or a vote of people cannot overtake the Constitution. It cannot go against rule of law. So I personally think you should, at some point, because NCA is extremely topical, at some point, they might ask a question about it. So that's why we are going to do Reference Race Secession of Quebec in great detail. In this case, Reference Race Secession of Quebec is going to appear multiple times across your syllabus, right? It's going to appear on 4 other occasions. So, but I'm going to say, refer to our discussions from the first class. So the reason is because right now we're going to do it in detail. The next time I'm going to touch it, which is like perhaps 2 classes from now, I will say, remember our discussion on this case? And then I'll move on. Now, what are the facts of this case? Quebec said, listen, we have a different legal system. Our people are different. Our language is different. Our culture is different. We want to separate. We want to come out of the federation. Fine. The question is, can they do that? Can a current government in Quebec hold a referendum or act in a way that attacks the Constitution? You see, most of these cases, you would realize, you'd see the government is trying to do something that it takes over the Constitution. But what is rule of law? Rule of law says, we don't care who you are. Law is the same. Constitution is the same, right? So this exact same thing the Supreme Court said. So the issue in this case was whether they would be able to secede unilaterally from the federation. Supreme Court said unilateral secession is unconstitutional. And the reason it's unconstitutional is because it will attack not just one, 4 unwritten principles. Number 1, federalism, because the way your country has been designed, you have Section 91, and then you have Section 92, and then you have, how the manner in which the country, I call it stitching together. The way the country is stitched together, you cannot just tear one part of it. So federalism, democracy, constitutionalism, rule of law, respect for minorities, essentially all these principles are getting transgressed. So now you might want to know, Henna, what are these principles? And I've explained each one of them in these notes. Please note these notes have already been uploaded on the website. These are a current copy of the notes, and they would be available to all our regular candidates. Okay. So before you ask me where are these materials, they are already uploaded on the website. I think we started the class with how you can access them if you are a regular student. Amar had discussed this. Yes, Iban, am I pronouncing your name correctly, Iban?
It's Eben, but it's okay.
Eben, sorry, my bad. Eben, what can I do for you?
The statement you just made now is what I want to ask. When we started this topic, you made reference to the fact that the rule of law is part of the Constitution. It's a written Constitution. Now, this reference to the ratio behind this reference with succession case, we're talking about the fact that we're considering federalism, rule of law, everything as unwritten principles. So I'm just trying to get this understanding. Is it okay for me to interpret that in as much as how the rule of law is enshrined into the Constitution in a written form, we can interpret the rule of law as unwritten principles? That's what I'm just trying to get.
No, that's a fantastic question, Eben. And at some point, in every class, I expect this question where they say, if it's written in the Constitution, how is it unwritten? You see, it does not tell you how it's reflected throughout the Constitution. It simply say it recognizes rule of law. The fundamental principle has not been discussed anywhere. Do you see what I'm trying to say, Eben? Where is it discussed?
Yeah.
Where is the definition of rule of law given? You only get this definition through case laws and articles and 1,000 other things that I will bombard you with. But where is the definition? How has it been defined? It recognizes the way it recognizes constitutional supremacy. So where is it given? How is it reflected? The same way it reflects Section 92, Section 91, and Section 92 division of powers. The same way it reflects democracy as a charter right. But where are these principles defined? Where is the heart and soul of the definition of this? It simply says, yeah, it exists. But how, so my mentor often says this, and I'll quote my mentor throughout our course. She says, Henna, there is law in text and there is law in context. These principles are laws or principles in context because they're not available in text. And even if they are available, you just make a reference to them. How have they been defined? What are the boundaries of rule of law? what is the definition of rule of law? How will it get reflected in like the day-to-day exercise of power or the day-to-day functions of the government? That is nowhere defined, Eben. Do you see what are you with me on the concept here?
Yes, I am. Yeah, thank you. Yeah.
You're very welcome. Any other questions before I proceed? Okay. So
Yes.
now, yes, Azina.
Yeah. So from what you're saying, will it be safe to say that rule of law are reflected in case laws and decisions by the
I often say this, that these fundamental principles, they are like plants that never stop growing. They are seeded in the constitution somewhere, but how they grow can never be controlled. Their growth, their reflection, at what point they're going to flower, at what point they're going to start shedding leaves, no one knows. You don't have a precise way in which they move. Do you see what I'm trying to say? Because there are so many authors that say, oh, so you believe in rule of law. So if you have any kind of measures that you take for, let's say, diversity, equity, and inclusion, they're against rule of law. Because you're essentially saying people who are underrepresented will be given preference over those who are already represented in the system. How is the system being fair? Because the law is now different. And then they would ask, so it's rule of law, but when it comes to sentencing in criminal code, why do you have aggravating and mitigating factors? Because you're essentially saying sentence is not the same for everybody, even when they have committed the same offense. So do you see, there is so much of contradiction that you can find. I can respond to each one of them. And that's because rule of law is an unwritten principle, but how you give decisions in court depends on common law methods of equity and precedent. And again, we are going to study this in topic 3. That's why you have to, like I said, you have to study foundations like, it's like this, if you study it in one flow. So you cannot really control how a particular principle is going to grow and thrive. That's why they're just seeds somewhere that are planted, but how they're going to grow, or can you control their growth? Can you shape their growth? No, you can't. Because in the same class, when we'll have for our regular students, some of you will say, oh, so when you exercise of discretion is essentially against rule of law. And they're not wrong when they say that. But it's just that how that discretion is exercised again needs to be seen in the context of rule of law. So we're going to talk about it. Like I said, there are more themes that, that we are just touching upon here. But yes, does that answer your question, Izine?
Yes, it does.
Any other questions? Okay, so let's just go back. Now, federalism, it's essentially a principle that recognizes that you have governments that operate at 2 levels. You have the provincial government and you have the federal government. And these provincial and federal governments, they need to work in tandem with each other. So secession of Quebec unilaterally transgresses the principle of federalism. Similarly, democracy, because you're essentially saying we are going to hold a referendum. What about people who would vote against it? So democracy is a continuing discussion of compromise and negotiating where consenting and dissenting views between minority and majority take place all the time. Then they said, you want to secede? You're going against constitutionalism and the rule of law, because the rule of law is a fundamental postulate of the constitutional structure. This definition is taken from Ron Corelli. It essentially says law is supreme over both governments and private individuals. Rule of law requires creation and maintenance of an actual order of positive laws, which preserve and embody more general principles. The relationship between the state and individual must be regulated by the law. And this was held in Manitoba language rights case. So where I've actually taken some sentences from case laws because they were written beautifully. or because they make sense in, in a given context, I've given the case law here. The preamble of the Constitution Act 1867 states that the rule of law requires all the governments at all levels to comply with the law. And therefore, what you're essentially saying, Quebec is unconstitutional. Any questions here about the case? See, foundations is a lot of storytelling. So if you're not fond of stories, I'm sorry, but this subject is going to be taught through a lot of storytelling. I am going to go dive deep into facts to indicate how a particular principle was transgressed.
I have a question.
Yes, Izine.
Please, how does minority rights, can you just expatiate on how it's connected to
So
this?
first off, minority rights is an unwritten principle that is not given in your syllabus. Essentially, there are not 6 unwritten principles, there are 9. So minority rights is one of them. What this essentially says is that the rights of the minority, because in Quebec, you just don't have French-speaking people, right? You also have substantial population of Anglophones. You also have people from different parts of the country. So when you say we are breaking away from Canada, are you not impacting on the rights of the minority who may not side with the Francophones? Ezine?
That's, yeah.
Yeah. So, like I said, they're not 6 unwritten principles. They are 9. I have no idea why NCA sticks to 6, because there is democracy, there is minority rights, and there is relations with the indigenous. Now, the third one that I've mentioned, you cover in topic 2. But for some reason, they don't talk about democracy and minority rights, which I don't know why, but it is not reflected in your syllabus. So much as I want to speak about it and also discuss case laws, that I'll just be discussing principles that are not given in the syllabus and wouldn't want to increase your workload. But
Okay.
does that answer your question, how minority rights get impacted?
Yes, thank you.
Excellent. So the next case we have is British Columbia versus Imperial Tobacco Canada Limited. Now, this is a fun case. So British Columbia came up with a legislation which was known as Tobacco Damages and Healthcare Cost Recovery Act. And the government of British Columbia said, listen to tobacco manufacturers, people who manufacture cigarettes. Listen, you make all the profits, you keep all the money. What happens then when people smoke? They get cancer. When they get cancer, the province, the state has to spend millions of dollars on their recovery. So essentially, tobacco manufacturers make the money and we have to bear the cost of the profits that they're making, because people get cancer and all sorts of diseases. And when they do that, the healthcare cost of province shoots up. So now, tobacco manufacturers, you will start paying a share of, or your share towards the healthcare costs in British Columbia. Obviously, tobacco manufacturers were not happy. They were up in arms against the government. And they said, how dare you? I mean, you cannot expect us to bear healthcare recovery. Government said, nothing doing. You manufacture cigarettes, you make billions of dollars in profits, and we lose billions of dollars because people smoke. So pay your share. Now what happened? The Imperial Tobacco, which is one of the manufacturers, they sued, and the tobacco manufacturer lobby. I hate them from the bottom of my heart. I'm not pro-smoking at all. They sued the government. Now, and the government, I forgot, they made this act retroactive since 1950s. So the government said, no. The application of this act is from 1950. So you will start paying your share since then. Obviously, these people got scared and they were a little rattled and angry, and they challenged the constitutional validity of the act on 3 grounds. First, division of powers, saying that the government does not have the power to impose such costs. We are not really going to going to dive deep into this ground. It's not relevant for what we are doing. Judicial independence, which again makes no sense. They said, when they are imposing these costs on us, they are performing the role of judiciary by imposing punitive costs. Again, doesn't make sense because clearly they were not doing that. And the third thing was rule of law. They said, you are unnecessarily penalizing tobacco manufacturers. The matter went right up until Supreme Court, and that's what we're going to discuss, because at every level, tobacco manufacturers lost because none of it made sense. So sometimes I say, what if they would have hired a better lawyer? But even if they would have hired the best possible lawyer, the thing is, the province is well within its powers under Section 92, because health falls under Section 92 of the Constitution Act 1867. Consequently, anything to do with health falls under the purview of the provincial government, right? So the court said, what are you even talking about? And it gave an elaborate understanding or elaborate explanation of how what tobacco manufacturers were saying essentially made no sense. They said that the appellants, in this case, the tobacco manufacturers, they misapprehend the nature and scope of court's adjudicative role protected by judicial independence. It was concluded to accept that they are not really transgressing the principle of judicial independence, because the province is well within its powers to do that. And they said that when it comes to rule of law, the reason why this case is important is because the courts gave a beautiful definition of rule of law. It said the rule of law embraces three principles. The first recognizes that law is supreme over officials of the government as well as private individuals, and thereby precludes arbitrary exercise of power. So the legislation applies to all. So Imperial Tobacco, you're not the only one. Every tobacco manufacturer is getting impacted in this. Second, it requires the creation and maintenance of positive laws which embody the more general principle of normative order. So they say that rule of law essentially says that laws need to, thank you, Abby, that laws need to exist. Legislation has to be positive, and they're doing that. Finally, the relationship between the state and the individual must be regulated by the law. So none of this is getting transgressed, Imperial Tobacco manufacturers. So can you please tell us, how is it against rule of law? Well, they were tongue-tied. They lost. You know what happened as a result of this? Fun fact. All the other provinces were waiting for the outcome of this decision. Because after that, Ontario passed a similar act. New Brunswick passed a similar act. Manitoba passed a similar act. And tobacco manufacturers had to pay their share in each of these provinces. Because let's understand, I mean, you promote smoking to school kids, and then they get addicted and they get all sorts of diseases where your share price keeps increasing and you keep making money. And taxpayers then have to foot the bill so that you can make your billions of dollars. So the fun fact was not the act, but what happened after the decision, because every province came up with a similar legislation and the tobacco manufacturers didn't know what to do. Any questions on rule of law now on this particular case? Okay. Now, why have I included this case? You may want to know, Hina, why did you pick this case up? I picked this case up because of, again, it's not given in your syllabus. But why am I spending time? It's because the way that court has described rule of law in this. So sometimes what will end up happening in your exam is that you will not have the time to write. Okay, and that's another thing. At some point I'm going to speak about how you're going to deal with questions when you're running out of time. What do you do then? Then what do? You simply pick up this one line, type, and within brackets write Manitoba language rights or British Imperial Tobacco. Because this will tell examiner two things. Number one, you understood the concept. Number two, not only did you understand the concept, you were able to identify the nerve center of that particular case. And number three, you wanted to write more, but you couldn't because you were running out of time. Do you see? So if you just pick these 3-4 sentences and mention it in rule of law, it's okay. So now your question might be, then why am I giving these details? The reason I'm giving these details is because if you start reading them directly from the case law, they are very bulky. Some of these case laws are over 150 pages. So, and you will take time to scoop out the facts. You have to give some context as to why these 3 sentences are important. I mean, I can arbitrarily say this is important, but you would need some background history. That's why I'm giving the facts. The next question that I'm often asked, Hina, do we need to write the facts? No. No, you don't need to. You need to focus on the ratio. And I often teach something which I can teach here because this is a free and introductory session. So if some of the candidates might not join, they should still be able to make the most of the session. Okay. I'll tell you what I'm suggesting you guys to do. Yes, Reema, what can I do for you?
Hina, just out of curiosity, were they under obligation to pay from the past retroactively?
Yes, that's the fun part, not just that. Yes. And they
Okay.
should. They should. So what you can do in order to make your reference easy in this exam? You can do it as a class activity and you can submit this to me if you want. I'll give you a lot of class activities if you like, because some of the candidates find it really helpful. Do you see what I'm doing?
Yes.
So if you go on like that, what will happen is you will end up having one line on every case, right? And you might want to know, Hina, where do we get this one line from? This is actually given, like I said, if you see the cases, I have in my conclusion given that one line or 2 sentences to you. What is wrong? Zoom is not zooming today for some reason. Okay, so then you can like literally take it from here. Law is supreme over government as well as private individuals and precludes arbitrary exercise of power. Literally, or just write legislation applies to all. What it will do is that in the exam, you can just pick up that one line, mention the name of the case, you'll have a table ready, proceed. This will come to your rescue when you're running out of time. Okay? All right. The next case we have is British Columbia versus Christie. Now, this is another interesting case. Now, British Columbia it imposed a 7% tax, which was known as, so British Columbia said that legal aid is expanding. We need to fund legal aid. And in order to fund that, we will have to increase or impose a 7% tax. Now, there was a lawyer by the name of Christie who said that, listen, I anyways deal with clients that come from the low income strata of the society. Now, if I pass on the tax to them, it is going to impact access to justice. And if access to justice is impacted, essentially their charter rights are impacted. So please take away this 7% tax. British Columbia, reduce your tax by 7% that you have imposed. Now, my question is, was Christie doing the right thing? What do you think? Was Christie doing the right thing? Any thoughts?
I
Okay.
think so. She was telling to reduce the tax, right?
Yes.
So legal aid should be for like available to everyone. And if you increase the tax, it will be expensive.
But is legal aid a charter right?
It is not.
Yes. Fasila, what can I do for you?
I just wanted to mention that Christie's clients do not necessarily have to have access to justice through Christie. Their legal aid, they can as well go to legal aid and have access to justice, and not necessarily Christie.
But
Absolutely right. Yes, Yajur.
legal aid doesn't mean like to provide someone aid. If you put taxes on it, it will become.
Legal aid is still what it is. Legal aid is free.
Mhm. That's what I'm saying.
So that is what the thing is. Legal aid is free. It is given on an income threshold. Legal aid is absolutely free.
So basically, you're putting a tax for
Yes.
low income group
Or
people.
no, you're putting a tax on everybody. This fee was imposed on everybody. It was called a legal aid fee, which everybody from the profession had to pay. So
Okay.
Christie said, if I pass on this 7% onto my clients, which come from low income group, they will not be able to afford me. Court said, we are not here to debate upon affordability. If someone is not able to afford legal services, you can go to legal aid. Legal aid is free of cost. This tax was imposed to fund legal aid. So if you're not
Okay.
able to
Okay.
afford regular services, go to legal aid. It's already there. How is access to justice getting impacted? B, where is it written that access to justice is a guarantee under the Constitution? Do you see my
Yeah, got it. Yeah, yeah.
We're
We
saying-
even
I mean, which place in your Constitution says access to justice is a given?
Mhm.
Access to justice is a value that we should aspire to achieve. But how is it a constitutional mandate?
got it. And government, I guess, is achieving by increasing the tax so that they can fund legal aid.
Exactly. Yes. Yes, Shireen, what can I do for you?
Two things. So, Hannah, firstly, then not access to justice, but the right is for legal representation and not for, the right to have somebody represent you in the court of law. Is that the right and not access to justice?
Correct.
Right.
And that you will anyways get.
Right. And the second part is the 7% tax. Is it right to say that it was the expectation that the lawyers who are paying the 7% tax absorb the tax themselves and not pass it on to their clients? That is what this person
No,
wanted
you
to
can
do.
pass on this 7%
Okay.
to your clients also. You should, ideally. Because if we pass on these 7%, this 7% tax on clients that can afford lawyers, what is it doing? It's expanding the pool of legal aid only, which essentially means that there'll be more lawyers
Right.
providing legal aid services because the
Right.
state would be able to pay them.
So those who can afford the extra 7% tax would hire the services of
Correct.
this
Otherwise,
person.
go to legal aid. That's it. So in a way, you're also expanding legal aid, right? And legal aid is not a constitutional mandate. Where is it given in the Constitution? Any other questions? So the court said in order for Christie to succeed, he has to prove that the Constitution mandates a general constitutional right to access to justice. And they said that the rule of law does not support a general right to a counsel in proceedings before courts and tribunals dealing with the rights and obligation. Rule of law does not guarantee this. Okay. You cannot say rule of law includes access to justice. Where is it written? And I kind of agree with the court. So I don't have problem with Christie's sentiments. Don't get me wrong. Christie's sentiments are on point. But when you see this from policy perspective, you would realize that what he's trying to do is exactly what the province is trying to achieve. If the province is imposing tax, legal aid tax, what is it doing? It is imposing this tax so that more lawyers can provide legal aid services, so that it can provide funding to lawyers and ensure that they end up taking low income group clients that are from low income groups. So Christie's sentiment 100% points to that, like 100% marks to that. But the challenge that he's trying to bring, that is problematic. See, in sometimes, you in law, I've given the kind of law I practice, I actually I work with the province. So I'm a lawyer for the province. I work for the government. Because I work for the government and because I work in the arena of access to justice, I can tell you that the sentiment is not that is being questioned. It's how you are trying to achieve that. You are trying to achieve that by invoking rule of law, which is incorrect. So sometimes, you have to distance yourself from the emotion and focus on the law. Do you see what I'm trying to say, everybody? Yes, Khurram, what can I do for you?
Can you explain in simple words what is the access to justice, please?
Access to justice simply means that you should not be stopped from availing legal services on the account of your economic status. So if someone is poor, they should still be able to afford a lawyer if they have been treated in an unfair, unjust fashion. Lawyers in Canada are extremely expensive. Legal profession is expensive. So does it mean that someone who's poor, who comes from reduced circumstances, is not able to afford legal services? Of course, that's unfair. So in order to provide access to justice, legal aid is there. It basically means if you have been treated in an unjust fashion, you still have access to legal services, and therefore your access to justice will not be denied just because you don't have the money to pay for it, pay for the lawyers. Does this make sense now, Khurram? Okay. Anybody else, any questions? Any questions?
Can I?
Sure. You don't have to
Thank
ask,
you.
and I just jump in.
Okay. So, is there only one factor that could be, considered access to justice, that is the affordability, or there are other factors?
There are access to justice is a huge issue. A part of it also means having more courts, having more judges, so on and so forth. But those are not getting invoked in the current case. Access to justice is a value. as access to justice is something that every country in the world is trying very hard to realize, to accomplish. There are multiple aspects to it. One of them is the economic aspect, which essentially means that the state should be able to provide lawyers and legal help to those who cannot afford it. All of you are going to become lawyers once you pass your respective exams, whichever province you should choose to go in. And if you start your private practice, it will not be possible for someone who makes minimum wage to afford you. So does it mean that someone who makes minimum wage should not be given access to legal services? No. So then how do you ensure that? You ensure that by funding legal aid in a way that there are lawyers who, because of the fact that they like advocacy, advocating for people from various strata of society, various vulnerable sections, get paid by the state to provide legal services. Okay, so that is access to justice. That is the economic aspect. There is administrative aspect of access to justice, which essentially means you should have enough courts and judges in the first place. The province should have the ability to establish courts. So that's the administrative aspect of access to justice. So access to justice is a value. It has multiple facets. The one that we are focusing on right currently is the economic aspect. Does that help, Mohammed?
Yeah, thank you.
You're very welcome. Yes, Vijay.
Good morning, Hannah. I wanna go back to the case law of secession of Quebec. You mentioned it's a practical question. You mentioned that the person who is a representative of the public in Alberta, he's calling for secession of. She's calling for a secession, but she said because it'll go against the Constitution itself, it won't ever happen or come to take place. So why is it that they still? Is it a political move?
I won't make political statements here.
Okay.
But I'm just saying that this is important because of what's happening in another province.
To hold on to power, maybe they do that. Okay, understood. I also have another question. Regarding the tobacco case law. What were the other? So you said all the other provinces also passed similar laws. What were the similar laws? What was in those laws?
That tobacco manufacturers in those provinces will have to pay for the healthcare recovery of those who get cancer.
Okay, for the past as well. Understood. Thank you so much.
So, Shireen, does this make sense when you were talking about access to justice? Yajur, I understand your sentiment, but it does not get reflected in law. I'm sorry. The next case we have is Trial Lawyers Association of British Columbia versus British Columbia. Now, in this case, and this is a 2009 case, in this, what had happened was there was a very long 10-day family law trial. Now, family law trials are very expensive. A 4-day trial sometimes can cost you $40,000. They're very, very expensive. So before this trial started, one of the spouses, she applied for an order requesting the government to please do not impose court hearing fee. So she said that, governments typically impose something which is known as a court hearing fee. And she said that, she's a woman of limited means. And the government should give her the exemption from paying this court hearing fee. The facts of this case they're very moving because this was more to do with the custody of her daughter, her child. And it was essentially a custody battle. So she said that this is a 10-day family law trial. I'm a woman with limited means. Please do not impose the court hearing fee. There are rules that say that if you are indigent, if you are someone who comes from a vulnerable section of the society, then you can be exempt from paying this fee. Her fee in 2009 totaled to $3,600. $3,600 is a substantial amount even today, but in 2009, $3,600 essentially meant 2 months' wages based on the minimum wage back then. So at her trial, her application was stayed by the court, and the court said, let's appoint interveners, let's appoint other agencies to discuss this court hearing fee. So they appointed Canadian Bar Association of the British Columbia, Attorney General of British Columbia, trial lawyers of British Columbia, West Coast Women's Legal Education. The question was, if they do away with this fee, is it against rule of law? It was held that, the Chief Justice here found that court hearing fee is unconstitutional if it causes undue hardship to the litigant who seeks adjudication. They said that if you have a litigant who is poor and who's already going through, difficult financial circumstances, when you add this court hearing fee, you put her or you put that person in the state of absolute hardship, and it would make this person impoverished. So they said that, litigants should not be prevented from accessing the courts just because they cannot afford a hearing fee by the government. So they said, while hearing fee is constitutional, if it's to an extent where it kills the purpose of coming to the court, then they become unconstitutional. So they said that hearing fee constitutional, yes. If it puts litigants under extreme financial hardship, it is against the principle of rule of law. Okay? Then comes the case of Ron Carelli versus Duplessis. This is my favorite case. Now, in this case, what happened was, Ron Carelli was a very successful business person. First of all, this case is from Quebec. Ron Carelli was a very successful businessman in Quebec, and he ran a restaurant, and he belonged to a religious sect called Jehovah's Witness. Now, Jehovah's Witness, they started to publish pamphlets against Roman Catholic community. As a result of that, multiple members of Jehovah's Witness, they were put behind the bars. Now, Frank Ron Carelli, because he was very successful and very rich, he could afford to pay the bail of these 375 members who were put behind the bar, who were actually imprisoned. So he could afford to pay their bail. Now, the issue in this case was, because the premier of Quebec belonged to Roman Catholics community, he compelled the commissioner of the liquor board to cancel Ron Carelli's license. He said that you please take away his bar license, because if you take away his bar license, he will not be able to make the sales he's making, and he will not be able to pay for bail of members who come from that particular religious sect. So clearly, in this case, what the premier was doing was arbitrary exercise of power. He was misusing his power to appease his vote bank. Ron Carelli's license was revoked. He sustained massive losses in his business. And he said that he filed a suit against the premier and said that you have to pay me $118,000 damages. This was in 1946. So do you imagine the value of $118,000 in 1946? It's close to 2 million. So he said that you have to pay this because this was the amount of business I lost thanks to you forcing the commissioner of the liquor board to cancel my license. And I know why you're doing it. You're doing it because I belong to Jehovah's Witness sect. And you have a problem with it. The matter went to Quebec's Court of Queen's Bench, and they found in favor of Ron Corelli. And this was overturned on appeal, and then it went to Supreme Court of Canada. And they said that what Duplessis had done was completely unconstitutional. What Duplessis had done was, in fact, arbitrary exercise of power. The very sentiment of rule of law is that it eschews arbitrary exercise of power. It says that as a public official, you cannot abuse the process of law. And that's exactly what the premier did. So in this case, the premier had to pay. And the sentence was, the unwritten constitution principle of rule of law means no public official is above the law. And therefore they can neither suspend it nor dispense it. You cannot, subvert rule of law under any circumstances. And the good part is that, okay, so because I teach this case and I have been teaching this case since the time I started teaching foundations, which was in 2021, this is like my 4th year of teaching foundations of Canadian law, and I've always taught this case. So this year, when NCA introduced an entire article on this, I was very happy. I said, NCA's listened to me. For the first time, I'm so happy. They have a full-blown article on Ron Corelli versus Duplessis. So rest assured, candidates who don't focus on other case laws and they say that, okay, we are only going to stick to the case laws that are given in the syllabus, will have no background about this case. They will not understand this context of rule of law. So I'm so glad they introduced, this is an entire article that they have introduced. I'll show you. Unfinished project of Ron Corelli versus Duplessis. And this is the new article that they've added, and we are going to now do this because it makes sense to do the case and the article together. So you see, the case said one thing, that it does not matter whether you are an elected official or not. If you are a public official, you are equally bound by rule of law. Lon Sawson's article talks about this particular sentiment of the court and says, you now need to expand it. What the court said in Ron Corelli versus Duplessis is so monumental that it needs to expand. And what is the central idea of this article? The author of this paper, Lon Sawson, looks at the areas of government decision-making in Canada that aren't reviewed by the courts. So not every decision or every step that the government takes is the courts can, I say that the courts cannot screen everything because that is against separation of powers, right? So not every area of decision-making that takes place in Canada is reviewed by the courts, such as foreign affairs, giving awards. These matters cannot be brought into court. They're non-justiciable. They argue this doesn't fit with the Supreme Court's case called Ron Corelli, which said that the government power must be exercised fairly. So he says that there is some contradiction because some areas the courts cannot review. And the Supreme Court said in Ron Corelli that the government needs to exercise its power in a fair manner, fair and impartial manner. This author believes that all government decisions should be open to some level of review by the court to make sure that the power is used honestly and responsibly. They end by saying that this idea is not about the law, but how the power should work in a democracy. Now, in your exam, if you do not have the time to go into the summary of the article, which is fairly large, then just write this. because I have differentiated articles like central idea. Central idea means if you don't have the time, just write this and move on. This is the crux of the article. This is the soul of the article. It simply says that certain areas that are not, that say that the courts cannot review, well, they should be open to review for the simple reason that a review by the court will ensure that the power is exercised honestly and responsibly. And they say this is not about rule of law. It's about how power needs to be exercised in a democratic system. Now, how and where are you going to use this article in the exam? Because I have also mentioned this, how and where to use this article. So if you see, you will see it in other articles as well. I've mentioned the central idea and how are you going to use this article? Where are you going to use this article? Because sometimes candidates have this thing, how am I supposed to use it? Where am I supposed to use it? Use this article to underscore the importance of trimming discretion. In any system, the government has a lot of discretion. It can decide what it wants to do. It has the ability to take decision solely based on discretion. It's government's discretion. You cannot question it. So wherever there is a fact pattern where the government has acted in a blatant fashion, where there is a legislation that is overbroad, wherever you see arbitrary and capricious exercise of power, where you see how law is being exercised or law is being implemented in an unfair manner, and purely because the government has the discretion to do so, there you are going to use this article. So wherever you talk about trimming discretion in the system, that's where you would use this article. So whether it's in a fact pattern question, in an essay type question, in a short note question, you should be able to identify this is the place where I'm going to use it. Now, what does the article say? The article explains what I've just said about Roncalli versus Duplessis, that the government officials cannot use the power the way they want. There are definite legal limits. Even though the courts supported this idea long back, some government actions in Canada are still not reviewed by court till today, thereby giving governments wide powers to, to exercise their power the way they want without any kind of accountability. So and you just have two watchdog agencies, elections, that's it, like not even two, one. Elections and media, they are the only ones who can sort of talk about what the government is doing, and you as citizens, you will get to cast your vote once in 4 years. But within those 4 years, the government pretty much has discretion over a lot of areas, and that is the problem Lon Sossin has. So when he talks about rule of law and discretionary authority, he says when the officials make decisions based on their judgment in some situations, that is essentially exercise of discretion. Have you seen this particular sentence? Your call, your judgment, take a judgment call. What do you mean by take a judgment call? It clearly means that I have the ability to do whatever I wish, because it's giving absolute discretion to me. So he says discretion is a necessary part of law. He's not saying it should be banned, no. But he also says that although it is a necessary part of law, you cannot oppose the fact that it is a source of tension, because it gives a lot of flexibility and unevenness to the system. I may have a different viewpoint on a particular issue as compared to Yajur, and therefore my exercise of discretion will be very different from his. So he said there should be legal boundaries. And this discretion that we are talking about needs to be exercised with a certain degree of judicial oversight. The next thing he talks about is the dilemma of justiciability. He says in Canada, and not just in Canada, in any country that is based on separation of powers as a fundamental legal principle, there are some issues that are not justiciable. Like, for instance, extraditing or extradition of a terrorist from another country is on the discretion of the government. They can choose not to do it. Imposing taxes falls within the discretion of the government. They can choose not to do it. The orange man down south is using this discretion to impose tariffs. And he continues to do so, right? You all know the orange man down south? You all know whom I'm talking about?
Mr. Trump.
Yes, the orange man. This, because it's a policy decision. You cannot question it. So he says there is a dilemma of justiciability. What I can and I cannot question. So he further explores the concept of justiciability as to whether a court can intervene on a particular matter or not. He says it is this justiciability issue sometimes that undermines the principle of rule of law, right? By giving substantial discretion to public authority and by curtailing judicial review. So and he also gives an example of a case law called Black versus Cretin, where the decision was whether the prime minister has the power to advise queen on the appointments, is it justiciable or not? And the court said this is a non-justiciable issue. The prime minister has absolute discretion to advise the queen on who needs to be appointed for what positions. The courts cannot question that decision. Once again, they said that when you say this question is not justiciable, you are taking away or you're scrapping the layer of good faith that you need to display in public decision making. You're scrapping the layer of fairness. You're scrapping the layer of impartiality. How will awards be given is something that the government decides. So they said that lots of decisions, plenty of areas, the government can do whatever it feels like. As a result of that, you erode public faith and confidence in the system because it goes against the very grain of the rule of law. Similarly, the passage calls for a deeper integration of judicial review with public accountability systems within the executive branch of the government. And they said that, there'll always be certain areas where there will be discretion. These areas will be political questions, foreign relations, and acquisition and exercise of security, sovereignty. Barring these three, you should exercise. There should be specific, or there should be space for some sort of judicial review. The author concludes by highlighting the tension between justiciability and the rule of law, arguing for a more nuanced approach to judicial oversight of discretionary authority. The author critiques the Supreme Court of Canada's approach to justiciability, asserting that the court often leaves significant areas of judicial discretion unreviewable. So this author, in fact, invites courts to do a more thorough job of reviewing the acts of the government and the executive. They said no public authority should be exempt from judicial review, as safeguarding the rule of law requires vigilance against arbitrary exercise of discretion, as was exemplified in Ron Carelli versus Duplessis. And therefore, he combines the approach that he's advocating for combines judicial oversight with institutional mechanisms within the executive branch to create a more robust rule of law culture, completing the project that Ron Carelli versus Duplessis initiated. Any questions?
So, in large, it says every public policy should have like
Barring
court
those
should,
three areas, yes.
barring those three, that's it, right? So the same thing, as you're saying, governments can just say it's like due to national security, we are doing this, and they are doing it down south.
What can we do? But I agree with Lon Sawson's take on the issue.
Okay.
I agree. I think because judges do not have the fear of losing elections, they should review everything that the government does. because government ends up taking populist measures. You know, we say that the governments usually play to the galleries. Their job is to stay in power. But judges are offered stability and security of tenure for a reason. It's because they are not scared of losing elections. And that's why areas that were traditionally unpopular, the judiciary had to step in and say, listen, we don't really care if you lose elections. This is not how we're going to, this is not a policy that will fly. Or we are strike it down.
Yeah, I also support it, but I'm also saying like the three areas should also not be barred. Like there should be.
Oh God, you want to bring about a revolution in the system? I'm with you. Come on, I'll walk with you.
Yeah, because down the south they are just naming everything as national security and passing the laws.
That's why an unfettered discretion leads to unreasonable outcomes. Yes, Shireen, what can I do for you? We're going to stop here. We have done enough case laws, and I wanted to do a new article, especially with those who might not sign up with us, so that they are able to see the change. The next article by Jeremy Weber and the other one, the case law, Singh versus Canada, those two, I'm going to do tomorrow, and we're going to continue with our journey on, with other unwritten principles. But yes, Shireen, what can I do for you?
I was actually going to ask which three areas. I seem to have missed it, but I found them in the notes. And Hannah, would I go too far if I said that maintaining rule of law, a big chunk of the responsibility lies on the shoulders of the courts?
Yes. Yes, you're not wrong when you say that. It's an absolutely logical conclusion. And that's why I often say that, and because I do other things as well. I often say, don't take your democracy for granted. It is the most fragile system in the world. Don't take it for granted. Don't take rule of law for granted. These are values for which people have given their lives. Let's safeguard it with all our might. But that's just me. I mean, there are some people who are not happy with democracy, and that's fine. I, for one, totally believe in it. With that said, I will close your class. I hope you enjoyed the session. For those of you who are our regular students and would be signing up with us, I'm going to see you tomorrow, and we're going to continue with our discussion. For those of you who will not be signing up with us, I hope this helped you, gave you some sort of insight into how you need to prepare for this exam. And yeah, take care and have a fantastic rest of the day. I don't know where you are, but where I am, there is no sun. So that upsets me. But we'll live with it. Yes.
Yeah, good morning.
Morning.
Yeah, my name is James. I just came very late because I wasn't sure with the time. I was trying to figure out what time is it. So I would like to know what time tomorrow are we meeting again?
9 a.m. Eastern time, 9 a.m. Toronto time.
Okay, perfect. Thank you very much.
You're
Thank
very welcome. Yep. Yes, Shekhar, what can I do for you?
No, hi. I just wanted to clarify with the time because even I thought that because earlier we were studying with the Alberta time. So I'm sorry, I didn't know that it's so it's 9
a.m. Toronto time, Eastern time.
Okay, so I'm in BC. I have to calculate. So it's 7 o'clock here. Okay. Thank you very
No,
much.
it's 6 a.m.
6 a.m. It's 6 o'clock. Oh.
6. I'm based in BC. 3 hours.
Can it be a little bit late?
Shekhar, actually, both Amar and I discussed the time. The thing is, if I delayed by an hour, you'll miss his constitutional law and other sessions that start.
Okay.
So right now, it's 9 o'clock in Calgary, and your next session with Amar is going to start. So the thing is, there are candidates who are a part of both the sessions. This is a challenge we've tried very hard to overcome. Unfortunately, I'm really sorry.
Actually, Hannah, we agreed to shift the constitutional law class until the 7th. So if you want to extend the class for another hour, depending on availability.
Let me see right now, because this is the time that has gone in. Amar and I will discuss, because I will have to speak to him. before I make any changes to the schedule. You can put in your suggestions, and we usually connect on Monday because both the days our sessions are packed, and we can then discuss. Does that offer a reasonable solution, Aaron?
I think your time in Toronto time, 9 o'clock, is just okay.
Okay, thank you. Yes, Khurram, what can I do for you?
In this new revised syllabus, the book is changed, or the burden,
It's a new edition, 5th edition.
5th edition. It will be just like the same one, or is there any difference?
There are some changes. We are going to talk about it.
Okay, sure.
Yes, Shekhar?
Just a quick question. Maybe I might would have missed. What all material do we need? We have all the material from Amarsa that's there. I mean, from you guys. Is there anything apart from this, any book or anything that we need to refer to?
I actually leave that decision on the candidates. They can decide if they need to go further, go deeper. It's entirely their choice. I do
So
not.
there's no book that we need to refer to or something like that.
I mean, in an ideal world, I'd request everybody to read the book. But then again, it's your choice.
Okay.
Yes.
Right.
Yes, Azine, what can I do for you?
No, I'm to see you after this session. I'm just reminding you.
What?
I'm just reminding you that I'm to speak to you after this session.
Sure, certainly. From my side, the class is over. Those of you who have no further questions may please leave the class. I will pause the recording now. See you tomorrow.